Your Honor, I offer these medical records of my client into evidence, but before I want the jury to see them, I need to redact certain pieces of information. You want to know what that means and whether or not the judge is going to allow that? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney practicing law in the state of New York. In a medical malpractice case or an accident case, I will always need to get my client's medical records into evidence. And there's a certain process in order for us to do that. But now, before the jury has an opportunity to actually see those records, there's certain things in there that I need to be removed. Now, I can't go ahead and simply remove them before admitting them into evidence. Why not? Well, my adversary, my opponent, may have a dispute with me about what's contained in those records. Let's say, for example, it's a car accident case, and now there's evidence, there's information in the hospital record to indicate that maybe my client had been drinking that night, or that someone in the emergency room smelled the odor of alcohol on my client's breath. And now I want to remove that information so that the jury does not see that or does not consider that. And you may be horrified to think, wait a second, you mean that they can actually do that? If there's an odor of alcohol and there's a suggestion that my client may have been drunk during the course or caused his accident, that we can actually get the judge to remove that information? Well, I will tell you there's specific case law that says that if that information is not relevant to treatment and diagnosis, then yes, the jury is not permitted to see that information and the witnesses are not permitted to discuss that information. So even though there may be the odor of alcohol or a nurse recognizes that the patient's eyes were bloodshot, that may not be relevant for the purposes of diagnosis and treatment. So let's say somebody went through a stop sign, caused my client injury. The mere fact that he had bloodshot eyes has nothing to do with causing the accident, had nothing to do with my client's damages. And the same thing about the odor of alcohol. My client may have had a drink 2, 3, 4 hours earlier and still had the presence or some smell of alcohol. And that fact alone is insignificant for the purposes of evaluating who's legally responsible. If I need to go ahead and remove certain portions of the hospital record, the best practices really is to address this issue with the judge before we start the trial, or before we start that morning knowing that we have an issue. Now the judge can hear legal argument from both sides, then make a ruling. So now when I get up to introduce those records into evidence, I'm not going to have an issue, and the judge will likely say, ladies and gentlemen, we are admitting this record into evidence subject to redaction. And that means that before the jury actually sees it, we will go ahead and actually remove those pages, those portions of the pages that have the offending information. So why do I share this great information with you? I share it with you just to give you an insight and an understanding into how these types of trials work here in the state of New York. You know, I recognize you've got questions or concerns about your own particular matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit for either an accident matter, a medical malpractice matter, or God forbid, a wrongful death matter, and you've got legal questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.